everyone thinks that this means you can't print your own you-know-what.
You said the word.
I did. Bleep me, Samir. But that is actually not the case. We are the Arms Attorneys. Today we are talking about what your rights are now that the Supreme Court has betrayed the Second Amendment on frames and receivers. Stick around. We'll go over briefly the opinion. I know that you've probably already watched another YouTube video talking about it, but what we want to talk about is why Chevron didn't apply and what exactly is not covered by this opinion and what you can still do at home. But before we get started, show your support for the Second Amendment by hitting the like button. And welcome, Edwin Walker.
Hello, it's great to be here.
And this is an unusual looking episode probably because we have Edwin and Emily, and also I did not change my clothes.
And we won't have to hear those comments about, oh boy, Emily's really let herself go. Is that what happens when Emily doesn't wear makeup? Oh my God. So maybe they'll say instead,
oh,
wow,
Richard shaved
his beard off.
I know, right?
Like, did that guy actually eat Richard?
Aww.
Yeah.
All right. Okay, so we are talking about the Supreme Court's ruling last week on frames and receivers. Of course, as you may remember, back to the year 2022, the ATF passed a rule saying that your 80% kits were, in fact, already completed firearms, such that they needed to have a serial number, go through an FFL dealer with the 4473, you get a background check, all that good stuff. They are just firearms covered by the Gun Control Act. What did you think about that at the time?
Now, this applies just to kits.
Just to kits.
Not to just the aluminum blank 80% receivers themselves.
Correct. The CFR does say parts kit, and that was we always said, I mean, way back before this was even a rule, when we talked about why is it an 80% lower. I remember very specifically years and years and years ago having the conversation with you, probably, Edwin, where I was like, where did they come up with this 80% rule? And the answer was no one knew. And that was the problem with the 80% rule, is that even back in the day before all this happened, we had this feeling like if there's no reasoning behind 80% being not a firearm, well, I mean, who's to stop literally anyone, any bureaucrat, any judicial officer from second guessing that and saying, actually, 90% or actually 60%, right?
Totally arbitrary.
Totally arbitrary. So what happened to the rule, Edwin?
Well,
Take us through the procedural posture.
Yes. Well, so the rule was declared unenforceable by a U.S. District Court in Texas, went to the Fifth Circuit. The Fifth Circuit agreed, said the rule is unenforceable, went to the Supreme Court. The Supreme Court, where everybody sort of assumed they would also say that the rule was enforceable, said no, the rule is enforceable, and they really kind of focused in on just a few things. What were those things?
Well, they looked at whether or not the Administrative Procedures Act would stop the ATF from regulating this under the Gun Control Act. So it would have been really splashy and fun for this to have been challenged on Second Amendment grounds.
Yes, but it wasn't.
And
of course, one of the rules that was overturned recently, the Chevron deference, people may be very interested to see how that applied to something like this, since it was directly challenging an agency action. It wasn't about a law that Congress passed or anything else. So how did the Chevron deference play into this case?
It didn't. It didn't. So essentially what we had here, and I'll say, you don't want to just make a Second Amendment argument here. I get it, because under the rules that govern how courts hear challenges, if they can resolve a case on anything other than a fundamental constitutional challenge, they're supposed to do that. They're supposed to do that first. And so I get it. You challenge under the Administrative Procedures Act, which is what controls how an agency is allowed to make laws. So that's our primary reasoning here, is we have the plaintiffs saying, listen, the Gun Control Act never was intended to apply to unfinished frames, and receivers. How do we know that? We know that because it talks about firearms and weapons. And, sure, there's that line in there that says that if it's readily convertible to expel a projectile, it's a firearm, but that really isn't what we're talking about here. That sounds reasonable to me. And if it's not what we're talking about here, then the Gun Control Act does not contemplate that an agency would be allowed to regulate and call a kit a firearm, but the court didn't buy it. And I thought it was interesting. I'll hand it to you in a second. But the court actually very specifically said, if Congress had wanted to regulate only operable firearms, it could have simply addressed weapons that can already expel a projectile by the action of an explosive, but they didn't. They said readily convertible in the Gun Control Act.
Yeah, and those are very interesting words as to why would it say that. A lot of states have mimicked that. Texas law says that, defines that as firearm, not only a firearm that can expel, but is readily convertible, readily assemblable to expel a projectile. And so this is now language that has pervaded all of the laws, this readily convertible. And one can only imagine that the legislature was probably talking about the people, and we've heard questions from them like, well, what if I just take the slide off and I keep my slide in one pocket and I put my receiver in the other pocket? Is that carrying a gun?
Yes.
And so would say, well, yes, it's readily assemblable, readily convertible, that it could be, that it would still be considered a firearm. And so that's what they focused in on. And they specifically named the polymer 80, right? Mm-hmm. Yes, because that kit, comes with, the way it's marketed, what was it, buy, build, shoot. Well, the court really focused in on that whole marketing buy, build, shoot language to demonstrate how easy it is to, in fact, put this together, to put this kit together to make it a readily assemblable firearm.
Right. So let's talk about why Chevron didn't apply, and then we'll talk about what this doesn't mean, because I think everyone's probably curious about what they can still do at home. So Chevron, you would think that the same court that brought us Bruin and Loper Bright could just put those things together and tear down this rule. They did not do that. And in fact, the plaintiffs tried to invoke Loper Bright. Essentially, they said, to the extent that there are ambiguities here, and they made arguments about how this is ambiguous, and so we should not be deferring to the ATF's interpretation. The court didn't, which doesn't mean that the rule goes away. It means then the court gets to decide, right, what it actually means. The court said it's not ambiguous at all. We find no ambiguity, which means we don't even get to the whole Chevron Loper Bright doctrinage, because it's just, there's nothing ambiguous.
Yeah. It doesn't even contain any kind of inherent ambiguities.
Right.
So now what they did say is that this ruling doesn't prohibit. So what the plaintiffs tried to do was throw out the entire rule altogether. But what they didn't do is they said, look, we're not going to throw out the entire rule altogether. However, there may be some kits which regulating them does violate the rule, that the rule does not apply to some kits. It applies to others. Like I said, they did single out this polymer 80. I believe that what they should do is they should adopt the Edwin Walker test, because Edwin Walker is not very technologically sophisticated.
Sure.
I don't put things together well. I don't build well. I was always the guy that tried to shove the misshapen puzzle piece into the hole where I thought it was supposed to go. I can't assemble IKEA furniture very well. It always winds up with either a strip screw or a broken piece of plastic, or some uneven door or flat surface. And so the rule should be that if Edwin Walker can build a firearm for the kit, it is regulated. If Edwin Walker cannot build a firearm out of this kit, then it is not regulated.
Right. So this was a facial challenge to the rule itself. So we actually don't know. And the court does note there's a spectrum of kits, right? Everything from something that is extraordinarily easy, can be completed in 30 minutes, so says the court, to something that actually is really quite technically challenging. You need specialized tools that most people don't have. You need specialized knowledge that most people don't have. And they left that open. Maybe that is something that cannot be regulated under this rule, but because the plaintiffs made a facial challenge, we're not going to address that here. Bring your own brand new challenge to that,
And
the people. So
sure. And as you sit there watching this video, if you have previously made a firearm out of one of these kits, are you required now to go get it serialized?
no,
No.
that's yours, baby.
Okay. However, word of caution, if you take it to a gunsmith or you take it to a dealer to have any kind of work done on it, what happens to it then?
They will serialize it.
So, one thing that this doesn't do is it does kind of barely touch on your right as an American to build your own firearm. So if you are going to the gun store or you're online and you're shopping for, let me get a receiver here, let me get a trigger assembly from this place, let me get a barrel from this place, let me get a stock or a grip from this place, you're still able to do that.
Correct. Although the receiver, if buying from an FFL, you're going to have to go through the background check process, 4473.
For a full receiver,
for a
but
full
not
receiver.
an 80%.
Sure enough, it only touches kits.
Right.
Although my guess is that FFLs are not going to sell without serializing. That's my guess. Even though the rule says kits.
All right.
I don't see it happening.
But you can still basically put your own kit together. You just cannot go to the store and buy a kit
Correct.
without going through the normal. I mean, if you're a hobbyist and you're like, I love building kits, then just be prepared that you will be required to do the 4473 background check, etc.
What if you have a Polymer 80 kit at home you have not yet assembled and it's unserialized? What do you do with it, Edwin?
I think you can just go ahead and build the gun.
Just build it.
Build it.
Build it. Build the gun.
Because you already have it. It's already in your possession. This regulation didn't apply to that.
Yes.
So you're good to go.
Yes, this is a rule which touches FFL dealers. This rule does not touch private individuals. So whatever you have in your hot little hands right now, congratulations, it's yours. Now, I think this is the question that's going to get us banned from YouTube because we're not really allowed to talk about this. Let's say that you have a printer at home that prints in a certain amount of Ds. I'm trying to not get shadow banned. Can you print a lower at home? Sure, right? Everyone thinks that this means you can't print your own, you know what.
You said the word.
I did. Bleep me, Samir. But that is actually not the case. Now there are, what is that rule about it not being metal detectable? You know that rule better than I do.
Yeah, well, you do have to, in order for you to not have a firearm does have to contain a certain percentage of metal so that it will be detectable. It is illegal to possess a truly undetectable firearm.
Right. So, but I mean, by the time you put it all together, you're going to get there. You'll have enough metal.
Sure.
Yeah. So this does not touch that. You got your carbon fiber filament and you got your printer. Ain't no logins at.
Right. And having a truly undetectable firearm, I believe, was a material element of a movie long ago.
Oh, hold on, let me back up. Ain't no law against that on the federal level. Your mileage will vary based on what state you live in.
So if you're familiar with that movie, answer in the comments below.
All right. Did we handle it? Did we cover all the questions?
Sure.
Okay. Well, we hope you enjoyed this episode. If you did, consider subscribing, hitting our like button, and even in Richard's absence, we ask that you fight the anti-2A algorithm by sharing this video. As Edwin said, please comment below. I have no idea what he's talking about. Was it before 1986?
No.
Well, then I should. Comment below and I'll educate myself. Until next time, we're the Armed Attorneys.